हेलो ऑल, वेलकम ऑन यूट्यूब। और आप लोग तो पहले से वेलकम हो, है ना। चलो, इफ़ आई एम ऑडिबल एट यूट्यूब, लेट मी नो। चलो, सो लेट स्टार्ट विथ क्वेश्चन नंबर आई थिंक 127 और 28. या there are some 12 questions left of the previous day. We will cover that also after we are finished with these questions. So these questions are related to union executive, which we will be covering president, vice president, the council of ministers, all these functionaries we will be covering. We shall also cover the state executive, but that will be covered in the later class, means tomorrow. That will include governor, chief minister and council of ministers, right? Okay. Chalo, let's start. These are the very simple and straightforward questions covered from Lakshmikant itself. Right. Under Article 368, the Parliament has no power to repeal the fundamental rights because under Article 368, so mainly Article 368 is the power of Parliament to amend the Constitution. Under Article 368, despite this power, Parliament cannot amend the fundamental rights. Why? Because they are the part of basic structure of the Constitution, and whatever is the part of basic structure of the Constitution cannot be altered by the Parliament. Parliament can amend anything in the Constitution provided they do not touch the basic structure thing, right? So the answer shall be D, right? Then the next question is, there are two statements and we have to see whether one second is the correct explanation of first or not. By amendment, Parliament cannot destroy the basic feature of the Constitution. This is the statement 1. The statement 2 says the power to amend does not include the power to abrogate the Constitution itself. Right? So we have, Parliament has the power to amend the Constitution. That means they can change anything in the Constitution. But what if they change the whole heart and soul of the Constitution itself? That will be altogether a fresh Constitution. तो ऐसा करने की आज़ादी तो हमने दी नहीं पार्लियामेंट को, right? So this is why that though Parliament can amend, but they cannot amend the basic structure of the Constitution, because minds of the Constitution makers were just to make our Constitution as a living document. It was not to give any power to the Parliament so that they could change the whole Constitution itself. अगर आप unfettered, unrestricted power किसी को देते हो तो वो तो कुछ भी कर सकते थे, right? बट हमारा कॉन्स्टिट्यूशन अगर हम स्टैटिक बना देते तभी बहुत सारी चीज़ें जो आज हमारे पास है दैट कुड नॉट हैव बीन पॉसिबल. राइट टू एजुकेशन, elementary education under Article 21A, that was not recognized as a fundamental rights then, but now in the 21st century, don't you find it is a necessity of everyone? हमने एजुकेशन पे ही काम नहीं किया, प्राइमरी एजुकेशन पे नहीं काम किया, तो इनोवेशन और आईटी में क्या पढ़ेंगे? यू कैन से दैट जब तक कोई बच्चा अच्छी प्राइमरी एजुकेशन पे नहीं लेता है, वो मैट्रिकुलेट कैसे होगा, वो इंटरमीडिएट कैसे होगा, वो आईटी कैसे जाएगा? So until and unless we make our grassroots education very strong, we will not be able to do much in the higher education, right? So that is one sort of example. So here we have to analyze that whether by this region Parliament were restricted the amending power. So is it that the statement 2 is the correct explanation of statement 1 or not? It is, right? Why we need to restrict Parliament from amending anything in the Constitution? Because amendment ka purpose is just to provide the synchronization of Constitution with the recent societal development. The purpose of amendment is not to abrogate the whole Constitution itself. वरना जिस तरह की आज सरकार है तो बहुत भयंकर भयंकर अमेंडमेंट हो जाते हैं, ठीक है? तो the answer is A, that both the statements are individually true, and second is the explanation of first. Which of the following are the principles on the basis of which parliamentary system of government in India operates? We have the parliamentary system of government, we do not follow the presidential one, right? So what are the features of Indian Constitution that ensures this parliamentary form of government? One is nominal executive head, second, vice president as the chairman of upper house, Third, real executive authority with the Council of Ministers, executive responsible towards the lower house of the people. What is our option? 1, 2 and 4. Why not? Oh, why 2? This is the feature. ये statement अपने आप में true है. But is it the feature of the parliamentary form of government? No. In Britain also, in United States also, the vice president is the chairman of their Senate. But USA is a presidential form of government. तो ये statement तो सही है. This statement, second statement, is true in itself. But this is not an essential feature of parliamentary form of government. इस वजह से हमारे देश में parliamentary form of government नहीं है. ये feature हमारे देश में है जरूर, right? So this statement अगर हम इसको exclude करते हैं, we have the nominal executive head in the form of president, and we also have a real executive head in the form of prime minister, right? So nominal and real executive, we have two kinds of executive. This is the feature of Indian parliamentary system. This is true. Real executive authority with the Council of Ministers. This is true, because these are the persons who shall be responsible towards the legislature, not the president, right? Then executive responsibility towards the lower house. So all these three are the correct choice. Answer shall be C, 1, 3 and 4. This cabinet form of government and parliamentary form of government both are same. So under a cabinet form of government, the cabinet generally remains in the office for a fixed term, so long as it enjoys the confidence of the popular chamber of the legislature, so long as it enjoys the confidence of the head of the state, and so long as it enjoys the confidence of an electorate. B. So which is the popular chamber in India? House of the people, Lok Sabha. तो जब तक लोक सभा में majority है, the government will be in office. In our country, the government do not enjoy a fixed tenure. Fixed tenure government का नहीं है. They remain until the pleasure of the president, and when the pleasure of the president will be activated, the time when they will lose the majority in the Lok Sabha, right? So the correct answer shall be so long as it enjoys the confidence of popular house of the legislature, that is 128. Under Article 368, the Parliament has no power to repeal the fundamental rights because these are part of basic structure of the Constitution. इसके जगह पे it should have been, हाँ, but see उसमें ये है कि no laws also. The amendments is one part, right? But 13 clause 2 will apply on the other things also. 13 sub clause 2 का scope 368 से बहुत बड़ा है. That will include your ordinance also, that will include bylaws, regulations, सब आ जाएंगे उसमें. So neither the law nor the amendments, both cannot hamper the basic structure of the Constitution, right? (132). Which one of the following is not an essential feature of parliamentary system of government? Which one? 2-3 वो parliamentary वाले chapter का ही है, तो इसलिए 5-6 question parliamentary से आएंगे. Which one of the following is not an essential feature of parliamentary system of government? Fusion of executive and legislature, nominal head of the state, collective responsibility, and fixed tenure of the executive. D. D for Delhi. Now fusion of executive and legislature is what? The people who are the part of the legislature, some out of them will be forming the part of the executive, like ministers. They has to be the member of either house of the parliament. If a person who is not a member of the parliament, either from the Lok Sabha or Rajya Sabha, for a period more than 6 months, they shall be ineligible to be a minister of the union, right? And only few, not all the legislature will be the part of the executive. Sir, 15% की limitation है. There is a capping of 15%, that only total number of 15% of the Lok Sabha, उतने ही जितने आते हैं, they will be the part of the Council of Ministers, right? So the answer here is D. When can the parliament legislate on a subject in the state list? When can parliament legislate on a subject which is given under the state list? 132D, हाँ 132 का डी था ना, यूट्यूब से रिप्लाई आ रहा है। यहाँ पे देखो 133, when can the parliament legislate on a subject in the state list? Ideally union list, parliament will make the laws. State list, state legislative assembly will make the law. On the concurrent list, both can make the laws. But there are certain situations when parliament also can make the laws under the subject which are mentioned in the state list. What are those situations? There are various situations. One is mentioned here. कौन सा वो situation है? First, if the parliament passes the resolution to that effect in the national interest, if the Supreme Court grants necessary authority, if the Rajya Sabha passes a resolution with 2/3 of majority declaring that the subject in the state list under the consideration is of national interest, if the president issues an ordinance transferring the subject from the state list to the concurrent list. C, right? So this provision is given under Article 249 of Indian Constitution, that once the Rajya Sabha passes the resolution with a minimum majority of 2/3 present and voting, there they do not need to secure the absolute majority also. Simply 2/3 of the present and voting होना चाहिए. And once the Rajya Sabha passes, the power to legislate even on the matters which are given under the state list goes on to Parliament. So this is the first step. Then who will make the law? Parliament together, that will include both Lok Sabha and Rajya Sabha, and then it will be transferred to the President for signature, right? So this is the provision given under Article 249. There are other provisions also during when the Parliament even can make the laws. When? So when two or more states request to the Parliament that please make the law, even if the matter is given on the state list, and 2 or more states are requesting to the Parliament, Parliament can make the law. Second one is this 249. Then to implement the international treaties. Then anything else? During the emergencies, state emergency के समय भी and national emergency के समय भी Parliament can make laws even in the matters given under the state list, right? Move on to the question number 134. What does the term federation imply? What does the term federation imply? Federation से क्या मतलब है? Fusion of power, separation of power, division of powers or devolution of powers? Division. D, devolution of powers, right? अब इन सारे टर्म्स का मतलब समझ लो. Fusion of powers meaning similar power is shared by two persons. Like legislative power and executive power is being shared by a similar set of persons. Ministers are also the part of the legislature and they are also the part of the executive. So fusion of two kinds of power in the one person. Fusion मतलब मिलना, है ना? तो जो प्राइम मिनिस्टर हैं, while he is the part of the executive, he is enjoying the executive power, and while he is the part of legislature, he is enjoying what? Legislative power. तो ये fusion of powers हो गया. Now separation of powers. Separation of powers among the different organs of the state, right? Separation of powers, you will talk legislature, executive, judiciary. So this is called separation of powers. But if you talk about the devolution of power from one unit to another unit, from center to state and then further to the local self-government, this is what? The devolution of power. Power is being transferred from one central source to various other authorities. Devolution of power, right? So devolution of power is one of the characteristic feature of the federation, right? Question number 135. Under the Indian Constitution, the residuary power is vested under whom? ये Indian Constitution की बात अगर करें तो, if you talk about Government of India Act 1919, 1935, residuary power was vested in Viceroy. But after making of the Constitution, the residuary power to legislate is vested in whom? Parliament. So ideally there is three lists: union list, state list, and concurrent list. Any subject which is not mentioned in even in this three lists, who can legislate on these issues? Parliament. So that is called residuary power, Article 248, right? Division is power, ये devolution और division. Division of powers में क्या होता है कि आप पावर बांट रहे हो, देयर इज ऑल्सो काइंड ऑफ शेयरिंग ऑफ पावर्स ओनली, पावर शेयरिंग बिटवीन टू, आपने कुछ पावर्स अपने पास रख लिए, कुछ दूसरों को दे दिया, ये भी डिवीजन ऑफ पावर है। बट मोर कॉन्क्रीटली जो आप फेडरेशन के लिए यूज करते हो, वो क्या यूज करते हो, डिवोल्यूशन ऑफ पावर्स। पोर्टफोलियो को आप डिवीजन ऑफ पावर्स बोल सकते हो। वंस द पावर वन चार्ज इज एलोकेटेड टू अनदर मिनिस्टर, right? Division of power you can talk in the general sense, but devolution you talk as a mechanism in the sharing of various organs or various levels of the government, right? Which schedule of the Constitution of India contains the three lists? बच्चों वाले क्वेश्चन, seventh schedule. The fifth schedule contains schedule areas. Sixth schedule contains autonomous district council, the 4 states. Seventh schedule 3 list. Eighth schedule the official languages of the states, right? So the answer here is C. Consider the following statements. The president nominates 12 members of the Rajya Sabha on the advice of the council of ministers. Second, the president has the absolute power to appoint and remove the chairman and the members of the statutory bodies at his discretion. Statutory bodies like National Human Rights Commission, these are the statutory bodies. National Human Rights Commission is not mentioned in the constitution, right? So uska appointment kaun karta hai? President. But at his discretion, no. Then how? It is not necessary always. The mode of appointment, how NHRC will be constituted, is given in the statute. जिस स्टैट्यूटरी बॉडी की बात करेंगे उसके एक्ट में लिखा होगा। एनएचआरसी कैसे अपॉइंट होता है, एक कमेटी फॉर्म की जाती है, सर्च एंड सिलेक्शन कमेटी, बेस्ड ऑन देयर रिकमेंडेशन। सो इट इज नॉट ऑलवेज द काउंसिल ऑफ मिनिस्टर्स, बट द मोड ऑफ देयर अपॉइंटमेंट, देयर रिमूवल शैल बी प्रेस्क्राइब्ड बाय द लॉ which is creating the particular authority, right? So this statement is false. First one is true. Our answer is one only. Consider the following statements. On the expiry of term of 5 years by the President of India, the outgoing President must continue to hold the office until his successor enters upon the office. Correct? The electoral college for the President's election consists of elected members of the Legislative Assembly of Delhi and Puducherry also. Correct? Both these statements are true. Our answer is C. Both 1 and 2 is correct. Which one of the following statement is correct? The Chief Election Commissioner of India holds the office during the pleasure of the President. B. The Governor of a state holds his office during the pleasure of the President. C. The Prime Minister can be removed by a resolution passed by both the houses of Parliament. D. The Speaker of the Lok Sabha can be removed at the pleasure of the President. The Governor of a state holds the office during the pleasure of the President. Is there any tenure prescribed for governor under the Constitution? 5 years, 6 years, ऐसा कुछ लिखा है? लिखा है. Governor has got the tenure of 5 years that is mentioned in the Constitution. But why governor is removed every now and then? Because he is not enjoying the security of the tenure. मैंने आपको बोला कि आप 5 साल तक ऑफिस पे रहोगे, लेकिन मैंने आपको ये नहीं बोला कि आपका जो 5 साल है that is safe. Wherever I want, I can remove. Similarly, the tenure of Chief Election Commissioner is secured. They cannot be removed directly at the pleasure of the President. There is a proper safeguard. There is a process to be followed before removing the Chief Election Commissioner, or before removing the chairman of UPSC, or before removing the judges of the court or Supreme Court or High Court, right? But governor का 5 साल का tenure prescribe किया है Constitution में, but that 5 years tenure is not secured. उसको कुछ safeguard नहीं मिली है, right? For that matter, a person who is going to the civil services, उनकी भी सेफ्टी और टेन्योर है. They are called the permanent executive. क्यों? क्योंकि they can neither be they can be removed only by those persons who is not subordinate to the person who has appointed him. उससे नीचे के रैंक के कोई भी ऑफिशियल नहीं हटा सकते उनको. And also, after holding a departmental inquiry, wherein they have been given a reasonable opportunity of being heard. So they are also having the security of tenure, right? Here for 139, our answer is B. The governor of a state holds the office during the pleasure of the president. That is indeed a pleasure of the Council of Ministers. In which of the following cases President of India is not bound by the advice of the Council of Ministers? First, the choice of Prime Minister. Second, the dismissal of government which refuses to quit after having lost majority in the House of People. Third, the allocation of business. Fourth, the dissolution of House when appeal to electorate becomes necessary. B. B में 1, 2 and 4. Why 4? What is the meaning of 4? This is a particular phrase or a paragraph from the judgment. There is a very famous case, Shamsher Singh versus State of Punjab. तो उस केस में सुप्रीम कोर्ट के एक जज ने, Justice Krishna Iyer, he was writing the judgment and he had made this following 3 observations: that president is not bound to seek the advice on these following matters. One is the choice of the prime minister when there is no clear-cut majority. Second, ideally there should be, now there is a convention which has been brought in by the various presidents. Like when K.R. Narayan was in office, so he started the letter of support system. That if you want to become the prime minister, bring the letter of support of 272 MPs, right? So letter of support का doctrine वहाँ शुरू हो गया. But ideally ये letter of support constitution में mentioned नहीं है ना? So the choice of prime minister, president is free. Secondly, the dismissal of a government which has already lost the majority but they are not resigning from the office. And third is dissolution of the house when appeal to electorate becomes necessary. जब जनता से दोबारा लोकसभा गठन करने का अनिवार्य हो जाता है, when it becomes necessary that government has resigned and there is no majority for any of the party, then what happens? The appeal to the electorate becomes necessary. So president will call upon the citizen of India, elect a fresh parliament or fresh Lok Sabha for you, right? So in these 3 situations, president is not bound. Our answer shall be 1, 2 and 4, right? Question number 141, which of the following statement is not correct? There shall be a council of ministers headed by prime minister to aid and advise the president, who shall act in accordance with such advice, right? Second, the president may require the council of ministers to reconsider the advice. The president need not act in the accordance with advice tendered after such reconsideration. The president shall act in accordance with the advice tendered after such reconsideration. See, so usually the advice of the council of ministers is binding upon the president. However, the president can refer back that please reconsider this advice. Now, if the council of ministers resends the same advice after further reconsideration by them, then it becomes binding upon the president. He will have to act accordingly. तो यहाँ पे क्या है? Not binding. This will be the false statement. हमें क्या करना है? Not correct ढूंढना है. 44th Amendment Act. So there were 2 amendments, 42nd and 44th. Both acted contrary to each other. Assertion is President of India is the chief executive of the government of India. Reason is President of India is elected by the members of the parliament and members of the state legislative assemblies. President of India is the chief executive of government of India. He is the head of the executive. This is true. Now, President of India is elected by elected members of the parliament and elected members of the state legislative assemblies. State legislative assemblies shall also include Delhi and Pondicherry. It includes, right? अगर इस तरह की statement है तो you will assume that it is also including Delhi and Pondicherry, right? Unless it is हुआ लिखा है excluding Delhi and Pondicherry, right? तो अब कंसिडर करके बताइए दोनों स्टेटमेंट, these are true in itself, but is this a reason to for India president to become the chief executive? No, he could have been appointed still and still be enjoyed. एग्जामिनेशन भी हम ले सकते थे प्रेसिडेंट का, फिर भी उनको चीफ एग्जीक्यूटिव बना सकते थे. So this was in the Constitution Assembly debates that why we are opting for the presidential election, because he was not only to be the representative of the union government, he was also to be the representative of the state government. इसी वजह से हमने प्रेसिडेंट के लिए इलेक्शन तो प्रेस्क्राइब किया, बट अ सिमिलर फंक्शनरी एट द स्टेट लेवल हु इज द चीफ एग्जीक्यूटिव इज गवर्नर फॉर द स्टेट्स, उसके लिए इलेक्शन नहीं होता है, ही इज डायरेक्टली अपॉइंटेड बाय समवन, है ना. So both the statements are true, but R is not the correct explanation of A, right? So answer shall be B. In which of the following cases the President of India is not bound by aid and advice of the Council of Ministers in deciding the question of removal of the governor, in deciding the question whether a member of Lok Sabha becomes disqualified to continue as the member, while exercising power to grant pardon, in dismissing a civil servant without any inquiry and hearing on the grounds of security of the state. B. B is saying what? In deciding the question whether a member of Lok Sabha has become disqualified to continue as member. This is a false statement. Why it is a false statement? It is based upon the advice of Election Commission of India. Now, is the advice tendered by Election Commission of India becomes binding upon the President or not? It is binding upon the President. Not binding on? No, not binding on Council of Ministers. But if the subject matter of advice is the disqualification of an MP, who will advise President whether to disqualify him or not? The Election Commission of India. In that case, it becomes binding. President will have to act in the advice which is tendered by the Election Commission, right? So answer shall be B. 143 is B. Which of the following is a correct statement about the President of India? He can address both houses of parliament and can summon the houses of parliament and also can send the message to either house of the parliament, right? Secondly, he can summon the houses of parliament but cannot send a message to either house of parliament. False. He can send the message. He can send a message to either house of the parliament but cannot summon the houses of parliament. False. He cannot send a message to either house of the parliament or summon the houses of parliament. Absolutely false. Who summons the houses of the parliament? President. Who dissolves the Lok Sabha? President. Who adjourns the houses of the parliament? Respective chairman, the speaker or the chairman, whosoever is applicable, right? So here the correct answer is A. Which one of the following statements about the impeachment of President of India is not correct? The charge for violation of Constitution shall be preferred by either house of the parliament. Second, the resolution has to be moved after at least 30 days notice is given in writing. C, the resolution has to be signed by not less than 1/4 of the total members of the house. And D, the resolution has to be passed by a majority of not less than 2/3 of the total membership of the house. We have the 4 statements. Which one is not correct? What is the process? B is not correct. B is not correct. So the answer shall be B. The process is that President can be impeached on only one ground, that is violation of Constitution. This charge upon the President can be initiated in either house of the parliament, be it in the Lok Sabha and Rajya Sabha, right? The 1/4 वाले जो requirement है, it is not mentioned in the Constitution, but rather it is mentioned in a particular act, है ना? President ऐसा कुछ discharge of functions, no, that is in another act. There is another act which have been passed by the parliament that mandates it, 1/4 of the support. Now this is not the majority. इस पे voting की majority नहीं है. Before the motion is adopted for voting, they required 1/4 of the members, जिस भी house में होगा. Then there will be an inquiry conducted. President will be given the due opportunity to represent, and फिर उसके बाद voting होती है. In the voting, it requires 2/3 of the total membership of the house, not the present in voting. 2/3 of the total membership of the house. This is the toughest majority which can be sought in the Constitution of India. 2/3 of the total. लोक सभा में है तो 2/3 of 543. राज्यसभा में है 2/3 of 245. Right? Because nominated members will also participate in the removal process of the president. Which one of the following propositions is a correct description of the powers of the President of India under Article 356 of the Constitution? Yes, Gurpreet, President also represents UT. Rather, President is directly ruling United Union territories. So he will appoint LG or the administrator for his functions. Question number 146. Which of the following propositions is correct description of powers of the President of India under Article 356 of the Constitution? First, if the Chief Minister, in spite of commanding the confidence of the Legislative Assembly, cannot run his government in accordance with the Constitution, the President can proclaim the emergency. Right? Even though the government in the state is enjoying the full majority, but they are violating certain features of the Constitution. Like they are not obeying the orders of the central, which is given. Central can pass mandatory administrative instruction on certain things, which are maintenance of telecommunication, railway, and instruction in mother tongue for the children of minority language in the residing in the state. So these are the situations where central government can give mandatory instructions to whom? State government. They will have to follow. And if they are willfully disobeying that, that is a violation of constitutional machinery. And this is mentioned in Article 365, that any such instructions, if violated by the states, will be construed as failure of constitutional machinery. और वैसे situation में भी emergency लगाई जा सकती है. Even then, the state government is in full majority at their legislature, right? Okay. Second is if the law and order in a state completely breaks down, the President can proclaim emergency. Third, the President can refer the matter to the Supreme Court for advice and act in accordance with such advice. Not necessary. The President cannot make a proclamation of emergency if the government refuses to make a report. Right? Which one is correct explanation of Article 356? A. A is correct explanation. One 47. Which one of the following is not correct about the powers of the President of India to grant pardons, reprieve, respite, remission of punishment, or to suspend, remit, or commute any sentence of any person convicted of any offence? Right? President can also grant pardon. Governors can also grant pardon. There is a slight difference between that. Governor cannot pardon death sentence completely, and he can also not pardon the sentences by court martial. Right? The President can do so in all cases where punishment or sentence is by court martial. The President may exercise such power in all cases where punishment or sentence is for an offence against any law falling within the executive power of the Union. The President may exercise such powers in all cases where the sentence is a sentence of death. The President may reject a petition for mercy, but must hear a petition for mercy before rejecting. B क्या कहता है? The President may exercise such power in all cases where punishment or sentence for an offence against any law falling within the executive powers of Union. This is correct. You have to find correct or incorrect. Not correct. हाँ. तो B, D में क्या है? The President may reject a petition for mercy, but he must hear a petition for mercy before rejecting. Right. And second one is saying that a President may reject such power in all cases where punishment or sentence is for an offence against any law falling within executive power of the Union. Why is it false? Achha, D you are saying false. Okay, sorry. Chalo. So answer is D. The President of India is elected by the Electoral College consisting of all members of the Parliament, elected members of the Parliament and State Legislative Assembly, members of Parliament, State Assembly and Legislative Councils, all the members of Parliament and State Legislative Assemblies. B. Elected members of Parliament and State Legislative Assembly. So the nominated members of Parliament are not included, and the members of Legislative Councils, whether elected or nominated, are not included. So answer shall be B. 149, consider the following statements. If a bill other than money bill is returned by the president for reconsideration of the houses and the bill again passed by both the houses of parliament with or without the amendment and again presented to the president, then it is also not obligatory upon him to declare his assent to it. False. Firstly, president has the veto to reject or to pocket or to send back for reconsideration, suspensive veto, right? So that will be absolute, suspensive and pocket veto, right? But he cannot use pocket veto on money bill. He cannot. He either can assent or he can refuse. He cannot send it for reconsideration. He cannot even use the suspensive veto on money bill. So वही कह रहा है, money bill नहीं है तो उसको return कर दिया. First half of the statement is correct, but the later half of the statement is saying that even after the bill has been reconsidered by the house and sent back to the president, still it is not mandatory for him to give the assent. This is false. Second half of the statement is false. A bill for the purpose of formation of new state and alteration of areas, boundary or names, that is Article 3, right? House of Parliament, and no recommendation of the president is required for introduction of such a bill. It is false. The prior recommendation of president is required for introducing any bill under Article 3, right? Prior recommendation is also required for introducing money bills. So 149 is D. The authority to declare war and peace under the Indian Constitution is vested in Prime Minister, Defence Minister, Parliament and the President. He happens to be the Commander-in-Chief of Indian Armed Forces. All the peace and war is declared in his name. However, practically it is declared by. Consider the following statements. Question number 151. Consider the following statements relating to the President of India. He may resign by writing to the Vice President. He shall continue notwithstanding the expiration of his term to hold office until his successor enters upon in office. He is not entitled to hold the office for more than 2 terms. He may resign by writing to Vice President. True. He shall continue. अभी ऊपर डिस्कस किया. This is also true. Now he is not entitled to hold. ऐसा, this is not a mandatory thing. However, there has been no president in India who has enjoyed more than 2 terms, full 2 terms. Because Rajendra Prasad was elected the president in 1950, got a 2 years tenure. Once in 1952, the general elections were conducted and then the electoral college was complete. Because 1950 में तो constituent assembly नहीं उनको चुना था. That was not a full-fledged election as a president. It was not having the full electoral college because electoral college should constitute of whom? लोक सभा, राज्य सभा and the state assemblies. तो वो करने के लिए 1952 में पहली बार elections हुई हमारे देश में. Then the college was completed. Then the presidential elections was held. So 1952 first term, 1957 is the second term. So he is the only president who has got more than 1 term in the office. उसके अलावा किसी president ने नहीं enjoy किया full time president after election. वैसे जस्टिस मोहम्मद हिदायतुल्लाह, he acted twice as the acting president. तो acting president को हम count यहाँ पे नहीं करते, right? So, but there is no such foundation that a president cannot be eligible for appointment more than twice. However, Jawaharlal Nehru wanted to bring such law to restrict Rajendra Prasad from a 3rd term, but उन्होंने खुद ही पर्चा नहीं भरा, right? So 3rd statement is false. 1 and 2 answer is B. The power of the President of India to issue an ordinance is an executive power, legislative power, constituent power and quasi-judicial power. Legislative power. If you see the article 123 of the Constitution, the heading to that is legislative power of the President of India. When the President of India is satisfied that the financial credit of the Government of India is threatened, he may direct reduction in the number of members in the Finance Commission, proclaim financial emergency, impose President rule, direct Parliament to pass a special financial bill. So we have grounds for imposing emergencies. For imposing national emergency, we have the ground of war, external aggression, and second is armed rebellion. Internal disturbance पहले था, now we have armed rebellion. यूएसए में होता है 2 बार के लिए, बाद में नहीं बन सकते। यूएसए में भी पहले नहीं होता था। देयर वाज ए प्रेसिडेंट वेरी फेमस, एफडीआर, यू नो, सो द टाइम ही कंटेस्टेड द इलेक्शन एवरी टाइम ही वन, so 1 2 3, थर्ड बारी जब इलेक्ट हुए तो मर गए। So then the government introduced in United States एक amendment that a person cannot be contesting more than twice. तो 2 बार से ज़्यादा वो प्रेसिडेंट नहीं बन सकता। कंटेस्ट कर सकता है, दोनों बार जीत गया तो तीसरी बार नहीं कर सकता, राइट? So in United States they have a law for that, but in India we do not have the law. Here this is a ground for imposition of financial emergency. National emergency, war, external aggression. Now state emergency on the failure of constitutional machinery, and financial emergency when the stability, financial credit of India is at the threat, right? Question number 154, consider the following statements in the respect of an ordinance promulgated by the President of India during recess of Parliament. Recess is the time when the Parliament is not in session, that period is called recess, right? So such an ordinance may be withdrawn at any time by the President. Such an ordinance shall be laid before both the houses of Parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of the Parliament or before that period if disapproved by both the houses. First statement, correct? That such an ordinance may be withdrawn by any time at the by the choice of the President. And second statement, what is the maximum tenure of an ordinance? 6 months plus 6 weeks. Actually it is 6 weeks, but if any house is not in session, what is the maximum gap possible is 6 months. So it becomes 6 weeks plus 6 months. So the second statement is also true, that if and both the houses reassembles within 6 weeks, government will need to get the approval of the Parliament, or if Parliament disapproves, it will fail then and there itself, right? Both the houses. Such an ordinance shall be laid before both the houses of Parliament. Second point, by both the houses. No, either houses. अच्छा, see the actual thing is, लक्ष्मीकांत ने गलत कर दिया है ऑब्जेक्टिव वाली बुक. It happens that Lok Sabha, Rajya Sabha, these are the two houses, and either of these two houses are not in session, an ordinance can be issued, right? What is the time limit? Suppose that today, आज हमारा क्या तारीख है, 15th of April, लोकसभा went out of session, है ना? अब 16th of April, President passes an ordinance, right? Now what is the time within which Lok Sabha said come to? लोकसभा कब आना चाहिए सेशन में? मैक्सिमम 15 तारीख को हुआ है तो 15 नवंबर अक्टूबर तक. So 15th October is the date when Lok Sabha must meet, right? अब from the date of reassembly of the later houses, 6 weeks time is there with the government. Government needs to pass it from both the houses. Now it is what, if the ordinance is passed by both the houses, it becomes law. और ऑर्डिनेंस अगर दोनों हाउसेस से पास कर दिया जाएगा तो लॉ बन जाएगा. टेक्निकली लॉ पास करने के लिए व्हाट वी रिक्वायर इज द परमिशन ऑफ बोथ द हाउसेस. सो इफ एनी ऑफ द हाउस इज डिसअप्रूविंग, द ऑर्डिनेंस विल लैप्स, राइट? सो दिस इज राइट दैट यहाँ पे ईदर ऑफ द हाउस होना चाहिए था, तब ये स्टेटमेंट सही हो. ठीक है, हाँ, बोथ भी, अगर दोनों हाउसेस ने भी कर दिया तो भी वो फेल हो जाएगा, ईदर ने भी कर दिया तो भी वो फेल हो जाएगा, राइट? एक तरीके से देखोगे तो स्टेटमेंट सही है, बट ये कंफ्यूजिंग स्टेटमेंट है एंड इट इज डायरेक्टली फ्रॉम द बुक. अगर दोनों हाउसेस ने भी रिजेक्ट कर दिया तो भी तो ऑर्डिनेंस लैप्स ही करेगा, एंड इवन इफ वन हाउस रिजेक्ट्स दैट विल लैप्स आल्सो. सो यू कैन कॉन्स्टिट्यूट द स्टेटमेंट एज पर यू थिंक. वी विल टेक इट कि दोनों हाउसेस ने रिजेक्ट किया है तो लैप्स कर गई, राइट? कहाँ से? Where is if? See, such an ordinance shall be laid before both the houses of the Parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of the parliament or before that period if disapproved by either house of the house. Disapproved by either house, इसको either house ही मान लो. कॉन्सेप्ट समझ में आ गया, राइट? लक्ष्मीकांत को बख्श दो. Ordinance promulgated by the President of India during the recess of the Parliament. Such an ordinance may be withdrawn at any time by the President. Any time. आज उन्होंने ऑर्डिनेंस लाया है, 15 अक्टूबर तक उनके पास टाइम है, उससे पहले कभी भी वो विड्रॉ कर सकते हैं. अगर 15 अक्टूबर तक उनको पास कराना ही पड़ेगा. If he fails to pass that, the ordinance will lapse. If Parliament disapproves that, ordinance will lapse again. Right? Match list 1 with list 2 and select the correct answers using the given code. This is the pardoning power and it's the implication of this pardoning power. So commutation, reprieve, remission and respite. These are the pardoning powers what the president enjoys. Commutation means changing sentence to a lesser form of, अगर डेथ है तो उसको लाइफ इम्प्रिजनमेंट कर दिया, लाइफ इम्प्रिजनमेंट है तो उसको फिक्स टर्म इम्प्रिजनमेंट कर दिया, इफ देयर इज इम्प्रिजनमेंट रिग्रेस इन नेचर उसको सिंपल कर दिया. सो चेंजिंग द फॉर्म ऑफ पनिशमेंट फ्रॉम सीवियर टू लेसर फॉर्म ऑफ पनिशमेंट, राइट? So A is 3. Now reprieve, stay, and remission, reduction in the quantum of punishment. Like say if 10 years punishment is provided, 5 years punishment will be provided. So C, remission. Remission is C ka 4. C ka 4. Then you have respite. Respite is A, stay of execution of sentence for a temporary period. B is awarding a lesser sentence. Wait. रिप्रीव इज फॉर टेम्परेरी पीरियड, जो थोड़े समय के लिए आप स्टे कर देते हो, दैट इज रिप्रीव. रिस्पाइट इज फॉर द एग्जिस्टेंस ऑफ एनी स्पेशल नेचर. ठीक है, हाँ, स्पेशल रीजन है. फॉर दैट मैटर इफ यू टेक एन एग्जांपल दैट इफ अ लेडी इज प्रेग्नेंट एंड शी हैज बीन गिवन डेथ सेंटेंस, so that there existing a special criteria for that. In that situation she may be given respite for a few time. उस, हाँ, संजय दत्त केस में क्या हुआ था? अच्छा, हिज वाइफ इज प्रेग्नेंट, तो वो तो पेरोल पे आया था ना, ही वाज गिवन रिस्पाइट. ओके, बट आई हर्ड कि संजय दत्त तो पेरोल पे आता था, बाहर नहीं मिलता है. वो तो है, बट स्पेशल सिचुएशन का एक एग्जांपल था, वाइफ प्रेग्नेंट, मतलब लेडी प्रेग्नेंट है. देयर मे बी अदर स्पेशल सिचुएशन लाइक सपोज दैट मेडिकल रीजंस में भी हो सकते हैं. पर्सन इज इनसेन, पागल हो गया, उसको सजा मिल गई. पागल आदमी को फांसी पे नहीं चढ़ाते हम, तुम पहले होश में आओगे, जानो कि तुमको फांसी मिल रही है, फिर चढ़ाएंगे. ठीक है, तो यहाँ पे जो कंफ्यूजिंग स्टेटमेंट आ गया ना, कम्यूटेशन का हमने क्या किया, ए का 3 है, सब्स्टिट्यूशन ऑफ वन फॉर्म ऑफ पनिशमेंट विद अ लाइटर फॉर्म, राइट? दिस इज कम्यूटेशन. एक बार ये ऑप्शन से देख लेते हैं. ए इज 3, तो हमारे पास ये दोनों एलिमिनेट कर लिया हमने, या मुझे भी एलिमिनेशन लगाना पड़ रहा है भाई. देन सी का 4 है, सी का 4 नहीं है, सी दोबारा से. लक्ष्मीकांत भाई ने क्या कर दिया है. कम्यूटेशन एंड वी हैव स्टे ऑफ एग्जीक्यूशन ऑफ सेंटेंस फॉर ए टेम्परेरी पीरियड, अवॉर्डिंग ए लेसर सेंटेंस इन प्लेस ऑफ ओरिजिनली अवॉर्डेड. ये एक्चुअली दोनों सिमिलर सेंटेंस हो गया है ना, इसलिए कंफ्यूजन है। ये ना सेकंड और थर्ड दोनों एक तरह का सेंटेंस आ गया है, दिस इज वाई। लेट्स ड्रॉप दिस क्वेश्चन फॉर अ वाइल, है ना, क्योंकि दिस सेकंड स्टेटमेंट और थर्ड स्टेटमेंट बोथ मीन्स द सेम, अवॉर्डिंग अ लेसर फॉर्म, अवॉर्डिंग अ लेसर फॉर्म, राइट। ओके, so this is my bad, sorry for it. 156, consider the following statements. The Constitution of India provides that the Vice President of India shall be the ex officio chairman of the Council of States. Second, the Constitution of India has not fixed any emoluments for the Vice President of India in that capacity. हाँ, फर्स्ट तो बहुत इजी है, दिस इज ट्रू. Second, the Constitution of India has not fixed any emolument for the Vice President in that capacity. In which capacity? एक्स ऑफिशियो चेयरमैन ऑफ पार्लियामेंट, राज्यसभा के लिए ही उनको सैलरी मिलती है. वाइस प्रेसिडेंट डज नॉट रिसीव्स एनी सैलरी फॉर द बीइंग ऑफ वाइस प्रेसिडेंट ऑफ इंडिया. ही विल रिसीव द सैलरीज ऑफ प्रेसिडेंट till the time he is acting as the president. For the remainder period of time, he will receive the salary as a chairman of the Rajya Sabha. Right? So this is false. दोनों लिखा जाता है. Earlier it was used as a council of states and house of people, but there was an amendment in 1954. Then we started to use the Hindi names altogether. So either you can write Rajya Sabha or you can write council of states. Originally में English names थे, council of states and house of people, right? So this statement is false because in that capacity constitution has fixed the emoluments. He receives the emolument for being the deputy ex officio chairman of the Rajya Sabha. He does not receive the emolument for being the vice president of India, right? Consider the following statements. The Vice President of India may be removed from his office by a resolution of the Council of States passed by the majority of all the members, all the then members of the Council and agreed to by the House of the People. Right? Second, an election to fill a vacancy caused by the expiration of the term of the office of Vice President shall be completed before the expiration of the term. Third, the Vice President shall, notwithstanding the expiration of his term, continue to hold the office until his successor enters upon the office. First, let's see about the removal. The Vice President of India can be removed from his office by which way? The effective majority in the Rajya Sabha and a simple agreement of the Lok Sabha. First statement is true. Second, an election to fill a vacancy caused by the expiration of the term of Vice President shall be completed before the expiration of the term. वाइस प्रेसिडेंट की इलेक्शंस के कंडक्ट कराने के लिए कोई टाइम ड्यूरेशन नहीं दी हुई है. देयर इज नो फिक्स टाइम ड्यूरेशन दैट 6 मंथ्स में होना चाहिए. फॉर द प्रेसिडेंट इट इज गिवन विद इन द 6 मंथ्स इफ द प्रेसिडेंट हैज डाइड और प्रेसिडेंट हैज रिजाइंड. इन दैट सिचुएशन 6 महीने के अंदर होना चाहिए. बट इफ द प्रेसिडेंट्स टेन्योर इज कंप्लीटेड, if the president's tenure is completed, 5 साल पूरा हो गया, तो in that situation we need a new president. What is the time duration? कब होना चाहिए election? Before his tenure ends. This is provided in Article 62. In a similar fashion, the elections for the office of vice president shall be completed before his tenure is being completed. But अगर vice president बीच में resign कर देते हैं तो उसके लिए 6 महीने के अंदर election कराने की constitutional mandatory नहीं है. Because what is the purpose of vice president? What is the function of the vice president? To act as the chairman of Rajya Sabha. And if chairman of the Rajya Sabha has resigned or is not in office, there are multiple deputy chairmen. They will be acting the same person. तो ऐसे कुछ खास जरूरत होती नहीं है वाइस प्रेसिडेंट की, राइट? तो इस वजह से कोई टाइम लिमिट फिक्स करके रखा नहीं है. Now consider statement number 3. The vice president shall not withstanding expiration of his term continue to hold office until his successor enters upon the office. This is true statement, right? So our answer shall be 1, 2 and 3. तीनों करेक्ट है. चलिए आगे. The vice president is elected by an electoral college consisting of members of both houses of parliament, elected members of both houses of parliament, elected members of both houses of parliament and the state legislative assembly, members of both houses of parliament and state legislative assemblies. A. Members of both houses of parliament. It includes elected as well as nominated members. The members of the state assemblies are not included into that, never. Right? So our answer is A. Question number 159. Assertion is that a candidate for the vice president must be qualified for election as a member of Rajya Sabha. The reason is vice president functions as the chairman of Rajya Sabha. So the person who has to act as the chairman of a house must be in the similar fashion be eligible to be a member of the house. आप कैसे एक्सपेक्ट कर सकते हो किसी को चेयरमैन बनने का जब वो उसका मेंबर बनने के ही योग्य नहीं है ना? दिस इज वाई द क्वालिफिकेशंस में क्या लिखा है हमने? The person who is willing to get elected as the vice president shall be fit enough to become the member of the Rajya Sabha. Now, president is the representative of people of India. This is why we have fixed he should be eligible to become the representative of India. That is House of People. House of People is direct representative of people of India. डायरेक्ट चुन के आते हैं ना वहां से लोग, इसलिए प्रेसिडेंट के लिए हमने लोकसभा कर दिया, राज्यसभा के लिए किसका कर दिया? वाइस प्रेसिडेंट का. So here both the statements are true and A is R is the correct explanation of R. So our answer shall be A. Which one of the following statements is not correct? The Vice President of India holds the office for a period of 5 years. We have to find not correct. The Vice President of India is eligible for re-election. The Vice President of India can act as a president only for a maximum period of 9 months. The Supreme Court of India has to look into all disputes with regards to the election of Vice President of India. Which is not correct? C. What is the period for which he can act? पागल को हम फांसी नहीं देते. For a maximum period of 6 months, within the 6 months, new president has to be elected. But their vice president can also act for a period more than 6 months. In which situation? See, there can be a vacancy in the house of the president, in the office of the president by 2 ways. Either the person has resigned or the person has died. In that situation, or the person has been impeached. There are 3 situations in which vacancy can occur. So in all these 3 situations, the same person, Mr. X, suppose he was elected as a president and there is no possibility that he will become again the president, that he will resume his office. So this is kind of a permanent vacancy, right? Person मर गए या फिर उन्होंने resign कर दिया या उनकी impeachment हो गई. In that situation, the vice president will take charge as the president and he will continue to function for a maximum period of 6 months. But in the situation when the president is sick, he is not available due to any work, in that situation there may be vacancy in his office also. President has become ill and is not able to fulfill his duties. Then who will fulfill his duties? Vice president. Until what period he will continue to do so? Until the president resumes his duty. So मान लीजिए आज president का election हुआ, tomorrow he becomes sick and he continued to remain sick for a period of 2 years. Then for this period of 2 years, vice president will continue to act as the president. वहां पे हम ये नहीं कर सकते कि सिर्फ 6 महीने ही आप काम कर सकते हो, right? Until and unless the president is removed, died, or they have been impeached, right? या resigned. In that situation 6 महीने. Otherwise more than 6 months. ठीक है? 9 months का ऐसा कुछ fixed limitation नहीं है. नहीं किया है. इम्पीचमेंट वर्ड का यूज किया है. कभी नहीं. नीदर फॉर द वाइस प्रेसिडेंट नॉर इवन फॉर द जजेस. Impeachment is only used for the president of India. For all other, it is removal. The word removal. You see Article 124. It is written word removal of the judges. ठीक है. So yeah, here we have to find the not correct option, and not correct is C. Our answer shall be C. Consider the following statement. No ground has been mentioned in the constitution for the removal of vice president. कोई ground mentioned है क्या? Vice president को हटाने के लिए कोई ground mentioned नहीं है. For president, violation of constitution. For vice president, nothing is mentioned. No resolution for a removal of vice president can be removed unless at least 21 days advance notice has been given. कौन सा है? 14 डेज नोटिस है। 161 161 का है, नो ग्राउंड मेंशन, तो ट्रू हो गया। सेकंड इज फॉल्स बिकॉज इट इज 14 डेज नोटिस, आवर आंसर शैल बी ए, वन ओनली। 162, consider the following statements with respect to duties of Prime Minister according to the Constitution of India to make rules for a more convenient transaction of the business for the Government of India and for the allocation among the ministers of said businesses. Second, if the President so requires, to submit for the consideration of Council of Ministers any matter upon which a decision has been taken by a minister but which has not been considered by the Council. कौन से स्टेटमेंट इसमें सही है? क्वेश्चन नंबर 162। हु मेक्स द रूल फॉर मोर कन्वीनियंट ट्रांजैक्शन? प्रेसिडेंट मेक्स द रूल, राइट? इट इज द एग्जीक्यूटिव पावर ऑफ द प्रेसिडेंट, ही विल मेक द रूल्स फॉर द कन्वीनियंट ट्रांजैक्शन ऑफ बिजनेस ऑफ द यूनियन गवर्नमेंट। सो फर्स्ट स्टेटमेंट इज फॉल्स। Which one of the following is constitutionally obligatory on the part of Prime Minister of India? Which one is constitutionally obligatory on the part of Prime Minister of India? As the President is the supreme commander of the defense forces, Prime Minister has to make all major decisions regarding the defense only after prior approval of the President. Second, Prime Minister has to communicate to the President all the decisions of the cabinet relating to the administration and proposal for legislation. As the ministers are appointed by the President, the Prime Minister must go by the presidential discretion in allocation of business. The Prime Minister, if he happens to be a leader of the party not having the required majority, should prove his majority strength in both the houses of parliament within the period stipulated by the President. Third one is false. Last one is false, because he will not need in both the houses, he will only need to prove his majority in the Lok Sabha. Third one is also false. While allocating ministers, he need not to abide by the discretion of the President. Second is correct. First one is also not a constitutional obligation upon the Prime Minister. So our answer is B. 164. Which of the following bodies are headed by the Prime Minister? National Integration Council, National Water Resource Council, National Development Council, Interstate Council and Zonal Councils. Zonal Councils, it is not headed by the Prime Minister, Home Minister is heading. Interstate Council, is it a permanent body or not? Interstate Council, is it a permanent body or it has been made a permanent body after enacting an act? So VP Singh government enacted one act. Earlier it was not a permanent body, it was simply given President may any time appoint, but an act was passed, Interstate Council, जिसमें Prime Minister is made the chairman. इस काउंसिल को साल में 3 बार मिलना मैंडेटरी कर दिया, बट बहुत सालों से अब इसकी मीटिंग नहीं होती, राइट? तो प्राइम मिनिस्टर इज द चेयरमैन ऑफ ऑल 1, 2 and 3 and 4, but he is not the chairman of 5th. So our answer shall be 1, 2, 3 and 4. Who of the following became the Prime Minister after becoming the Chief Ministers? इनमें से कौन कौन प्रधानमंत्री बनने के पहले चीफ मिनिस्टर रह चुके हैं? तो चरण सिंह यूपी, वीपी सिंह was never a chief minister, he was simply the minister of defense and finance during the time of Rajiv Gandhi government before घोटाला हुआ, and he came out of the government, started a new party, जनता पार्टी की सरकार में प्रधानमंत्री बन गए, ठीक है? HD Devagowda was also not a chief minister. PV Narasimha Rao, Charan Singh and Morarji Desai, these 3 persons were the chief ministers before they became the prime minister, right? अच्छा, सॉरी, फोर्थ सब में, अच्छा वीपी सिंह वाज द चीफ मिनिस्टर कब? अरे हो क्या, ऐसा ऑप्शन कह रहा है? So as for my knowledge, VP Singh was never a chief minister, but we'll have to find out. Can anyone Google? Google करो जरा. Then Morarji Desai, wasn't he a chief minister? He was a chief minister. UP. Achha. And Charan Singh was also chief minister. PV Narasimha Rao was also chief minister. So he was Deve Gowda साहब तो नहीं थे. ये भी थे कर्नाटका के. अच्छा. New fact. Thank you. So all of them were chief ministers. ऐसा कोई ऑप्शन है क्या? 1, 2, 3, 4 and 5. Sorry then. So all of these were the chief ministers. All of them were the chief ministers. पक्का Morarji Desai was the chief minister. Google कर लिया आपने? Okay. So all of them 1, 2, 3, 4 and 5. All of them were the chief ministers before they became the prime minister ones. Which of the following are included in Article 78 of the Indian Constitution defining the duties of the Prime Minister? To communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of Union and proposal for the legislations. To take prior presidential sanction for budget before submitting it to the Parliament. Budget is a money bill that will require the prior recommendation of the President before it has been brought to the Lok Sabha. Right? Budget can only be introduced in the Lok Sabha, then it is transferred to the Rajya Sabha. To furnish the information called by the President regarding the administration of affairs of the Union, if the President so requires, to submit for the consideration of the Council of Ministers a matter on which a minister has taken a decisions without submitting the same for the consideration of the Council beforehand. What second is saying? To take the prior presidential sanction for the budget. It is not the duties of the Prime Minister though, right? A budget before presentation in Parliament, that is in Lok Sabha, needs the prior recommendation of the President, but it is not the duty of the Prime Minister. So first, third and fourth, our answer shall be B. Which of the following are not mentioned in the Constitution of India? Which of the following are not mentioned in the Constitution of India? Council of Ministers, collective responsibility, resignation of minister, office of the Deputy Prime Minister. Yes. Council of Ministers is mentioned. Collective responsibility of ministers is also mentioned. Resignation of ministers and office of the Deputy Prime Minister is not mentioned, right? So our answer is A, 1 and 2. अच्छा, which is not mentioned, so our answer will be C, 3 and 4. ठीक है, चिंता की बात नहीं, ऐसे मैं एग्जाम में बहुत गलती करता था. एक बार तो 5 सवाल ऐसे गलत करके आए थे, और वो भी इकोनॉमिक्स के, जो मैं बहुत अच्छे से पढ़ता था. पॉलिटी आती थी और इकोनॉमिक्स में पढ़ता था, बाकी नहीं पढ़ता था. हिस्ट्री और ज्योग्राफी तो मेरा बैल बराबर है, लाइक एब्सोल्यूट बुलशिट. तो कंसीडर द फॉलोइंग स्टेटमेंट्स. हाँ, इंडिया का डायग्राम देखा था. तो कंसीडर द फॉलोइंग स्टेटमेंट्स. द प्रेसिडेंट कैनॉट फंक्शंस विदाउट द यूनियन काउंसिल ऑफ मिनिस्टर. द सॉलिसिटर जनरल इज द हाईएस्ट लीगल अथॉरिटी. यूनियन काउंसिल ऑफ मिनिस्टर कैन फंक्शन फॉर सम टाइम इवन आफ्टर द डेथ और द रेजिग्नेशन ऑफ Prime Minister. In the absence of Prime Minister, only the Home Minister can preside over the emergency meeting of Union Council of Minister. First, President cannot function without the Union Council of Minister. This is true. The word written in the Constitution is shall. Shall means it is mandatory. So first one is true. The Solicitor General, false. This is true. This is false. The Union Council of Minister can function for some time. It cannot. As soon as the Prime Minister dies or resigns, it is the it has been called as a ship which sails and sinks together. तो एक बारी एक गए तो सब गए. This is the concept of collective responsibility. So this is false, right? तो हमारा आंसर क्या हुआ? Only one, right? Death. हाँ डेथ भी हो जाता है तो काउंसिल ऑफ मिनिस्टर चली जाती है ना, इट इज ए न्यू काउंसिल ऑफ मिनिस्टर. If the new prime minister takes charge, there will be new council of ministers. The caretaker prime minister is appointed for the time being, but once the full-fledged prime minister will come, it will be the new council of minister has to be sworn in. 169, according to Article 74 of the Constitution, which of the following statements relating to the advice tendered by the minister to the president will be correct? It shall not be inquired into any court. It can be inquired into Supreme Court. It can be inquired into all courts. It cannot be inquired into high courts. Any advice which has been given to the president by the council of minister, it shall not be inquired in any court. The advice are beyond judicial review, right? Actions based upon the advice, they become the part of the judicial review. Based upon the advice of the council of minister, if president takes any action, that is under the judicial review. It shall not be inquired into any court. According to the Constitution of India, if the president so requires, it shall be the duty of the prime minister to submit for the consideration of the council of ministers any matter on which a decision has been taken by a minister but which has not been considered by the council. This ensures what? This ensures what? कौन सा? 170. Okay, sorry. Which of the following constitutional amendment acts has made the decisions of the council of ministers binding upon the president of India? 42nd and 44th. ये दोनों हम इसलिए लेके चलते हैं because in the 42nd amendment act it was made completely binding, but 44th amendment act allowed president to send for the reconsideration. Still it was made binding. So the answer shall be A. The answer shall be A. According to the Constitution of India, if president so requires, for the consideration of council of ministers, any matter on which a decision has been taken by a minister but which has not been considered by the council, this ensures, कहने का मतलब ये है कि once a minister has decided but he has not consulted with other counterparts, other members of the cabinet, so it will be required to send back to the cabinet. What does it reflect? ये क्या दिखाता है? Collective responsibility, one for all and all for one के concept, right? As per the provisions of the Constitution of India, who makes rules for more convenient transaction of business? President. We have already discussed it. एक दूसरे स्टेटमेंट में प्राइम मिनिस्टर का जब हम डिस्कस कर रहे थे. The accountability or the responsibility of prime minister and cabinet to the Lok Sabha is intermittent, indirect, at the time of election, direct, continuous and collective. It is direct, continuous and collective. कोई indirect नहीं है. The council of ministers, they are the part of the legislature, they are the part of parliament, and they are directly responsible to the Lok Sabha, and they are collectively responsible to the Lok Sabha. D. अगर यहाँ पे हम लीगल रिस्पॉन्सिबिलिटी लिखते तो लीगल रिस्पॉन्सिबिलिटी ऑफ मिनिस्टर्स, आर द मिनिस्टर्स इन इंडिया लीगली रिस्पॉन्सिबल फॉर देयर एक्ट? नो, इन इंडिया मिनिस्टर्स आर नॉट लीगली रिस्पॉन्सिबल. इन यूनाइटेड किंगडम दे आर हेल्ड लीगली अकाउंटेबल. दे अगर वो साइन करेंगे दे विल बी लीगली बाउंड. Which one among the following features of the Constitution of India is indicative of the fact that the real executive power is vested in the Council of Ministers, which is headed by the Prime Minister? Parliamentary democracy. Because ultimate executive power shall be exercised by the authority of the people, and people's की representative कहाँ है? House of People में. तो parliamentary democracy. Whenever the Constitution requires the satisfaction of the President for the exercise of any power or functions by him, it means the personal satisfaction of the President, the satisfaction of the Council of Ministers, the satisfaction of the members of the Parliament, none of the above. So it is the satisfaction of Council of Ministers, right? So these were 50 questions for the day, right? कल वाले, हाँ, which one? जो पर्सनल सेटिस्फैक्शन है, आई एम नॉट श्योर अबाउट इट. सनसेट सिंह, हाँ, देख के उसको बताते हैं आपको. There are some 15 questions. So tomorrow is also we have a class of RTFQ. So tomorrow we are planning to do more questions, around 100 के आसपास करेंगे. From the executive portion and parliament पूरा करेंगे. अच्छा, because I was informed for Sunday. तो वो कंफर्म हो जाएगा आपको बाद में कि कल हमारी क्लास है या नहीं, राइट? कोई नहीं, वो आपको इन्फॉर्मेशन मिल जाएगी, नॉट टू वरी. ऐसा नहीं कि जो कल वाला क्वेश्चन है वी विल नॉट बी डूइंग, उसको भी करेंगे, ठीक है. ये क्वेश्चंस जो थे दिस वेर बेसिकली डायरेक्ट, थोड़े से डायरेक्ट क्वेश्चन थे, इसमें ज़्यादा कुछ दिमाग नहीं लगाना था. ये वाइल आई एम प्रिपेयरिंग द क्वेश्चन मेरे 3 सोर्सेज होते हैं, इंडियन एक्सप्रेस के आर्टिकल और लक्ष्मीकांत की ऑब्जेक्टिव पॉलिटी बुक और प्रीवियस ईयर क्वेश्चंस. वी आर फॉलोइंग द 3 सोर्सेज. आज के 50 आउट ऑफ 50 क्वेश्चंस वेयर फ्रॉम ऑब्जेक्टिव पॉलिटी बुक लक्ष्मीकांत के, सो दैट आप उसको वो दोबारा रिवाइज ना करना पड़े. दिस इज वाई मैं उसको कवर कर लेता हूँ क्लास में, ठीक है. क्वेश्चंस आते हैं उससे, डायरेक्ट क्वेश्चंस आते हैं, है ना. ओके, चलो, थैंक यू.